Hey everyone, after having reread yesterday's Supreme Court decision on same-sex marriage in some greater detail, once again I have to react with dismay at the specific legal reasoning and arguments that Justice Anthony Kennedy used in his majority opinion to find that the Constitution protects same-sex marriage, or requires governments to recognize same-sex marriage. Now, this isn't surprising because this is a tendency that Justice Kennedy has exhibited in every gay rights opinion that he's written in the past. He actually is responsible for writing the majority opinions in pretty much all of the Supreme Court's gay rights cases, from Roma versus Evans in 1996 to Lawrence versus Texas in 2003 to U.S. versus Windsor in 2013 to Obergefell versus Hughes now in 2015. And in all of those cases, Justice Kennedy's majority opinions have failed to base gay rights on what I believe to be the soundest premise that's available. In this latest case, he preferred to identify the ability to get married legally as a liberty interest rather than that's protected under the Due Process Clause of the 14th Amendment, which applies the requirement of due process to the states rather than just to the federal government. And basically, he premised his ruling more on that basis than on the Equal Protection Clause, which you heard me mention, if any of you were paying attention, which you heard me mention in my video from yesterday reacting to the decision with my first impressions. Now, you may have heard me mention in that previous video, as well as in past blog posts, that I think the Equal Protection Clause is really the main constitutional provision that requires all American governments, federal, state, and local, to recognize same-sex marriages and treat them equally with opposite-sex ones. That's because the Equal Protection Clause is the clause that establishes and enshrines a non-discrimination principle in American constitutional law. Before 1868, when that amendment, the 14th Amendment, was adopted, it wasn't so clear that American governments were forbidden constitutionally to discriminate on the basis of race, sex, or now sexual orientation. Unfortunately, Justice Kennedy didn't see fit to come out and do what courts normally do in equal protection jurisprudence and find that sexual orientation is a protected class, namely meaning that it's the kind of personal characteristic similar to race and gender based on which the government is presumptively not supposed to discriminate against people. Anytime the government treats people of one race differently from people of another race, or treats people of one sex differently from people of another sex, that triggers what is called strict scrutiny, which means the courts will take a very close look at the law that's being challenged and will hold the government to very high standards in determining whether the government has a compelling interest or at least an important interest in applying that particular law, and whether the restriction that the government has applied is the least restrictive means available of serving that compelling or important government interest. So Justice Kennedy seems to have been reluctant in all of his gay rights cases to simply come out and say, yes, sexual orientation is a suspect classification. In other words, this is the kind of personal characteristic based on which governments cannot treat one group of Americans differently from another. He seems to prefer to avoid that question altogether and focus on the idea of marriage as in this case at least, to focus on the idea of marriage as a liberty interest. But for reasons that I've already made clear in my past videos, that whole approach to same-sex marriage, to the marriage equality question in general, is wrong-headed. The marriage issue is not fundamentally about personal liberty. It's not about what people are free to choose to do or not to do based on their own free will. Because, even in just jurisdictions that don't, or before yesterday, did not recognize same-sex marriages in the United States, gay couples were still free to live together and, to live out the spiritual and emotional meaning of marriage in a de facto sense, even if they were not considered legally married in the de jure sense. So it's not a question of, and this is something Justice Thomas pointed out in his dissent, and that was one part of his dissent with which I actually agreed. You know, it's not fundamentally about liberty. The government, you know, when governments refuse to recognize same-sex marriage, that's not a prohibition. A lot of people call those bans on same-sex marriage. I never use that terminology because I don't think it's accurate. It's not about banning anything. The government isn't telling you, you do this or else, or don't do this or else, right? It's simply saying, if two men or two women want to live together and call themselves married, they can call themselves married, and if they can find a religious institution or some other community institution to give that union its blessing, they are free to do that, but don't expect us, the government, to give them a marriage license, to give them that legal status of a married couple, or to give them all the legal benefits and privileges that come with that. So it's not fundamentally about what people are free to choose to do or not to do, it's rather about how the government treats them and what the government gives them, as well as what status the government bestows upon them. And that's not a liberty issue, it's an equal protection issue. What's more, there's another reason why I think that Justice Kennedy's approach to this case and other cases like it is so misguided. By not, you know, wrestling with the issue of what sexual orientation is, whether it's a choice or not, and whether it therefore should be considered a suspect classification or not, by sidestepping that issue, Justice Kennedy has left the whole cause of marriage equality open to the accusations of its opponents who say it'll create a slippery slope that will soon require us to recognize polygamy, incest, and bestiality, or rather polygamous, incestuous, and bestial relationships. Now, the bestiality analogy is obviously false for the simple reason that animals can't consent. And so that's all the argument you need to make in order to distinguish bestiality from homosexuality. When it comes to incest, again, incest is a bit more complicated because the main rationale for banning incest is that it can lead to the procreation of children who will have lots of genetic genetic diseases that can handicap them physically and or mentally. Now, that doesn't say much about whether homosexual incestuous relationships should be allowed, because obviously those can't lead to procreation, and so it's a bit complicated in that context. What's more, there's also the case of polygamy. Already, a graduate student by the name of Frederick DeBoer has published an article yesterday, before the sun set after the Supreme Court ruling in Obergefell versus Hughes. Mr. DeBoer published an article at Politico.com in which he argued that polygamy is the logical next step. Why deny people the ability to get married, to enter into plural marriages, as they're somewhat euphemistically called, if we're going to allow them to enter into homosexual marriages? Why contemplate one deviation from the traditional nuclear family and not another? Now I personally think that, polygamy is fundamentally distinguishable from homosexuality. But there you go. The reason for that is that homosexuality is an innate biological orientation that is not a choice. It's something people don't choose and that they cannot change. And it's not inherently harmful to others. Now, you can make a case that polygamy is not inherently harmful to others, although the way it's been practiced throughout most societies that allow it throughout history, it's tended to be very patriarchal and oppressive of women, and even younger men and many other members of society. One can argue that it doesn't have to be that way, that those problems are not intrinsic to the practice of polygamy itself. And what's more, a polygamous, laws that allowed polygamy would obviously allow a woman to marry multiple men just as much as they allow a man to marry multiple women. What's more, I don't think most people in society would ever enter into polygamous marriages, even if it were legalized, and so a lot of those social negative knock-on effects of polygamy probably wouldn't be much of a problem anyway, just because most people are weirded out by it and wouldn't enter into it in the first place. But I think the fundamental distinction is that polygamy, unlike homosexuality, does not stem from an innate biological orientation. Now, I had this argument in one of my law school classes, and one of my classmates argued against my position by saying, well, it seems there's scientific evidence that human beings are biologically predisposed to be sexually promiscuous. We're not really engineered to stick with one person for the rest of our lives. We want to play the field, men and women alike. And I pointed out, even if that's true, the fact remains there's no biological orientation that forces us to have more than one spouse at a time. And that's what polygamy means. Under the existing laws of the land, you can have multiple wives or husbands if you want, as long as you don't all have them all at the same time. You can have them serially. You just have to make sure you divorce your previous or existing wife or husband before you move on to your next one. right? And that would be just as consistent with, you know, an innate biological predisposition towards sexual promiscuity as polygamy is. So I don't think that argument quite holds water either. You know, so I think the fundamental distinction between polygamy and homosexuality is that homosexuality is not a choice, whereas polygamy, or people's sexual preferences that lead them to want to be polygamous, those are choices. Those are things that people can change or control. Those are just lifestyle choices, and there's no imperative, moral or legal, for governments to cater to and recognize and accommodate those lifestyle choices. So I think that's the difference. Now, if Justice Kennedy and the rest of the Supreme Court had been willing to delve into the equal protection analysis and declare sexual orientation a suspect class, then they would have been able to get into that issue and make it clear so that the laws of the land, Supreme Court jurisprudence, would include legal reasoning that would foreclose the possibility of polygamy, of a constitutional duty for governments to recognize polygamous marriages. And so that distinction between homosexuality and polygamy would be enshrined in the law, and there wouldn't be this concern about a slippery slope. You see? So that's why, that's one more reason, among others, why I think that Justice Kennedy's approach to this case was misguided and wrong-headed. Not surprising given his track record, but still misguided. Basically, he did the right thing for the wrong reasons. Yet again. So that's my take on this, and once again, feel free to join the discussion. I look forward to it. Peace out.